All right, so we're gonna go through some bills this afternoon. Welcome to voting list number 10. We have a number of bills before us. I don't think we have any withdrawn bills to vote on today, so. Because I thought you might. No, so do we want to hold the first one for Hershey, or do we want to just get started? All right, we're getting started because we said we were doing voting right after bill hearings, and that's where we are. So let's go to Patrick.
Yeah, so the first bill on the voting list is Senate Bill 798. This is the constitutional amendment that would establish an individual's fundamental right to reproductive freedom, including but not limited to the ability to make and effectuate decisions to prevent, continue, or end one's own pregnancy. And it prohibits the state from directly or indirectly denying, burdening, or abridging the right unless justified by a compelling state interest achieved by the least restrictive means.
Second.
I have a motion and a second on the favorable. Senator Reedy.
Madam Chair, I just wonder if I could ask questions about the bill from the analyst.
Absolutely.
So thank you very much. So this bill, first of all, the wording of it is interesting. And I'm curious if we can talk about, we know what the bill's about. We know what it's about. But it talks about how you have the one of the pieces of language that I was most interested in and a little bit concerned about is the not limited to. So we're talking about the ability for someone to have access to an abortion to make decisions about a pregnancy, right? When you say not limited to, what else is that including? Why do we want to say not limited to in the language?
Yeah, I mean, so
I know it's not your bill. I'm sorry. I'm just asking, like, can you comment on what that covers? Is that what else would we be talking about?
Yeah, so you're referring to line 18
Yes.
of the bill.
Yes.
So what the bill does is it establishes a fundamental right to reproductive freedom. So reproductive freedom is the right that would be enshrined in the state constitution. And then it provides some elements that this would include, which is the ability to make and effectuate decisions to prevent, continue, or end one's own pregnancy. The wording says include, but not limited to, the ability to make and effectuate decisions to prevent, continue, or end one's own pregnancy. So these elements would be included, but they are not exclusively what would be included under the protected right. The right that's protected under this language is the right to reproductive freedom.
So why do we say not limited to? Why don't we just say reproductive freedom, including the right to I still don't understand why not limited to is in. I just think it opens it up much wider. It's much broader than what we're trying to focus on in the amendment.
I mean, I think that's a question for the body. What are the parameters of the right that's being instituted in the state constitution?
Is it fair to say that well, I'm not going to ask you to characterize because I'm talking to you as the analyst, but it's been talked about this being a fundamental right and that Roe versus Wade got rid of a fundamental right. And so we're trying to protect that in Maryland state constitution. But it's correct legally to say Roe versus Wade did not establish as a fundamental right. It's still subject to regulation. But what we're doing is we're saying it's a fundamental right in this amendment. I say we, it's not my bill. But what the bill is doing is a fundamental right, which means you really can't supersede it. What does this do? What does this do to current law in Maryland that things that have some limitation like notification for parental notification? What does this do for parental notification? Because that would be a limit on someone's reproductive freedom.
So the bill doesn't deal with existing statutory provisions relating to abortion care services. I think a way to think about the bill is what it does is any time that there's a state action under the framework of this bill with the right being enshrined in the state constitution, the standards that would be established through this bill would create the framing for permissible state action. So any proposed action, legislative, regulatory, that's state action, would be subject to the parameters of this bill. So the first question would be, is there a reproductive freedom at issue? Then maybe does the state action in question directly or indirectly deny, burden, or abridge the reproductive freedom? If so, then the question would be, is there a state action justified by a compelling state interest? And is this achieved by the least restrictive means? So any state action would be subject to the framework of this right. And it would ultimately, if there is a dispute, it would ultimately be within the province of the court to resolve that question, whether it's a permissible action.
So, okay, so basically it doesn't strike down any current laws we have. Maryland's law is very permissible on abortion. There's really no limits hardly at all. There are a few things dealing with minors, and so this doesn't really change, doesn't strike down any Maryland laws, would not strike down any, like, for example, regulating abortion clinics, which don't really regulate them much, but would it preclude us from having any sort of regulation of an abortion facility for health and safety or cleanliness, or that what it would mean is, like, what would it do with that?
I mean, it's difficult to speculate on hypotheticals. Each circumstance, may have particular facts that would be relevant to the analysis. I think that the answer I can give is that any state action, regulatory, statutory, that would directly or indirectly deny, burden, or abridge, a reproductive freedom would be subject to the level of scrutiny that would be established under this bill.
So right now, though, we pass a law that says, or a better example, a regulation is promulgated about a particular medical practice of abortion, a certain way of doing abortion, or a regulation is promulgated about regulations with an abortion facility, because we're expanding abortion facilities dramatically because of previous legislation. So what this means is it does not preclude us from either passing a law or passing a regulation that deals with some sort of regulation on an abortion facility, but it does mean that anything could then be subject to court challenge. And the state could conceivably have to go to court, even just to justify a safety regulation, right? I mean, right now you don't have to. You have the regulatory process, the legislative process, but now there's going to be an additional hurdle on anything you want to do with safety, correct?
Yeah, I mean, I think any state action that would impact the reproductive freedom at issue, any state action that specifically would, under the language of the proposed constitutional amendment, directly, indirectly deny, burden, or abridge the right, whether it be something proposed like you've suggested, it would be subject to the standard that's laid out in the constitutional amendment. The state action would have to be justified by a compelling state interest, and it would need to be achieved by the least restrictive means.
Compelling state interest. We've that's in there. We've come back to that. That's a strict scrutiny standard, correct?
That's correct.
Under Roe v. Wade, my understanding is that was a lesser, more of an undue burden standard that Casey later was decided on, an undue burden standard, which is a lower standard. So this is going to be the highest standard. Okay. And I think maybe my last question, I know we have a couple amendments, a couple of us have talked about to try to make this a little bit stronger, a little bit better, I guess is a way to say it. So right now in the state of Maryland, if we pass this, a baby in the womb that's 2 or 3 weeks from being born. So put aside all the stuff about Texas and all the stuff about or whatever, and what everybody may think about when life begins. the debate on this isn't about whether you think abortion should be illegal after 15 or 20 weeks, or whether you should think it be illegal all the way through pregnancy or not at all. It's really about if we're going to have really no limits pretty much on abortion. Right now, if we pass this, is there any rights that a baby at 35 weeks gestation has outside of the mother?
Yeah, I mean, I think the answer is that the constitutional amendment doesn't deal with any of the existing statutory framework that's applicable. And so right now under Maryland law, Maryland's law prohibits state restrictions up to viability except for regulations to protect the life and safety of the pregnant woman. And just it is the case that the law treats that decision as a clinical decision to be made between the woman who's pregnant in consultation with their healthcare provider. What the constitutional amendment would do would enshrine the fundamental right to reproductive freedom in the state constitution and establish this heightened scrutiny that's specified in the constitutional amendment for evaluating any state actions that directly or indirectly would deny, burden, or abridge the reproductive freedom.
So until baby is born, both the baby and the father don't really have any rights even right before, correct? It's only, okay, so that's, okay. All right, no, good to know. Thank you very much, Madam Chair.
Thank you. Are there Senator Mounts?
Yeah, I just want to follow up on that because the question about the current standard and what this legislation or what this constitutional amendment would mean is that, the ability, the first phrase is, the right to reproductive freedom, but then it goes on explicitly to say that the decision to prevent, continue, or end one's own pregnancy. So I don't think that in my view, I think the way this reads, and this is just a perspective, but if someone were to challenge that, I don't think that the viability standard would overcome this constitutional right that would be created. I mean, do you understand? Is that? I mean, I think that's different than the way the bill was just explained. As far as the question was, how would this affect the current regulations and standards for abortion right now in Maryland? And maybe my view is of a minority, or maybe it's off base. But the way I see it is this is explicitly saying that, you have a fundamental right to continue, what are the words? Prevent, continue, or end one own's pregnancy. That speaks specifically to that viability standard. So anyway, I just wanted to, I don't know if you agree with that or if I'm off base. I don't want to make sure that I want to make sure that I'm saying something that is accurate. But that's the way I see it. Do you agree, or is there a disagreement on how that would apply to the current statutes regarding or regulations dealing with abortion?
I mean, I think it's ultimately going to be a matter for a court determination if there's ever a dispute that that pertains to standards in existing law or future standards. Any state statutory or regulatory action would be subject to this constitutional framework. So it would ultimately be the province of the court to determine whether a hypothetical state action is infringing upon this right in a manner that doesn't comply with the level of scrutiny that's laid out in this language here. So it would need to be justified by a compelling state interest achieved by the least restrictive means.
Okay.
Thank you. Back to Senator Reedy.
God, I mean, is it now an appropriate time to consider an amendment? I'll go ahead. You go ahead. Well, you want to go ahead. All right. So I have an amendment I'd like to offer on the bill.
Do we have it?
You should have it. I have
I
two
have-
I've drafted.
I have one amendment. It's from Senator Mouts and it's 613623 number 1.
Could we,
That's the only amendment that I've received.
I thought we were working with the committee on amendments. No? Okay.
I've only received one amendment from Senator Mouts and it's 613623 number 1.
I have two. Can he start and how would I make a copy? How do I do that? Okay, yeah. Not how do I know how to make copies, but I mean,
Lay it on the glass.
yeah, thank you. I'm sorry, I thought we worked through.
Senator Mount, you can go ahead and proceed with yours then.
Okay, I haven't done an amendment in the Senate. I'm used to saying, so much be the reading of the, yeah.
So ordered.
Yeah. Yeah, so I have we have an amendment. It's been circulated. I hope everybody has a copy and the number is it's 798/613/623/1. And we were just discussing some of the explicit points in the constitutional amendment. However, in the explicit points in the constitutional amendment. However, this amendment applies to the two words or the one word right before those explicit statements are made, and it's the word freedom. And in reading this, freedom is a concept that is open to interpretation. And I understand that it goes to the general intent of the political movement behind the development of this constitutional amendment. However, there are different ways to look at the rights that are created by the constitutional amendment. I think there's one perspective where you would look at this as being, enshrining the right of abortion, and the other is enshrining the right of healthcare decisions. And my approach to this is we're dealing with healthcare decisions. I could go kind of off the rails talking about when you get into reproductive freedom, what does that, we're not being recorded, are we? We are being recorded. So we can go off the rails talking about reproductive freedom and different interpretations and things like that. However, this amendment and what it's dealing with is ultimately a healthcare decision. And there's a debate, a political debate, where pro-life will say that abortion is not healthcare. Pro-choice will say abortion is women's healthcare. It is healthcare. And ultimately that's what we're getting to. And so the idea of this amendment is to clarify, what we're talking about in this constitutional amendment. And so what the amendment would do is strike the word freedom. And freedom is wonderful, but with this, we're talking about this amendment, and it would replace the word freedom with healthcare choices. So the constitutional amendment would read, has the fundamental right to reproductive healthcare choices. And then the rest of the amendment would carry on as it's drafted. And to me, that goes to the heart of this very emotional and important issue. Whereas the word freedom is not focused on healthcare. It's I don't know how to describe it, but to me that would be an improvement on the language that's included in the amendment. And when these amendments are put into law, they can be interpreted any way in court in a number of different fashions. You can never predict the situations or circumstances in which they be challenged or how they would be applied. And this is a fundamental right that would be put in the Maryland Constitution. So if we are focusing, if this amendment is to be focused on reproduction, healthcare, it would make sense to make that fundamental freedom specifically to healthcare choices, which would include receiving information about the decision that's being made. It would focus the debate and the discussion directly on the issue of this right and responsibility that's being created. And so I think this is feel very strong. This will be an improvement on the way the amendment is currently drafted. And I kind of filibustered a little bit. Would choose.
Okay, there's a motion and a second on amendment number. The Mounts Amendment. Are there any questions? All those in favor of the amendment, raise your hand. Okay, that's 3. Those in opposition, please raise your hand. That amendment fails. Okay. All right, so Senator Reedy?
Thank you, Madam Chair, and thank you to the staff for making those copies quickly. Sorry, I miscommunication on that, but I do have an amendment, and I do think it's a very important amendment to put an additional safeguard in this bill. I have amendment, it's on your desk, but amendment 983929-1. And if you look on page 1, in line 19, after decisions, we have just inserting the term free from coercion. And I think this is really important. It's an issue that's actually was brought up by some different groups that are not the typical groups that engage on this issue about people being coerced into making a choice that they don't want to make. And you can look at that a number of ways: being coerced into being coerced into being impregnated, being coerced into having an abortion. And it covers coercion. That term will cover a lot of areas that would allow someone to have the confidence that they won't be forced into doing something they don't want to do as it relates to their reproductive decisions. So I think it's actually a nice little safeguard language, and I would just move the amendment.
Okay, there was a second. So we have before us a motion and a second on amendment number 98, the Reedy Amendment 1. All those in favor, raise your hand, please.
No, nobody wants to talk about it, huh?
Okay, and all those opposed, please raise your hand. That amendment fails.
All right, well, I've got one more, Madam Chair. Since we're not getting to have any good discussion about it, I'm going to have to offer another amendment. It's an important bill. It's an important issue to talk about, and I know it's not fun, but I'm not the one who introduced the bill. So I'm not. So I do. This is one thing I think is just a transparency thing for the voters. I would like to make sure that the ballot language reflects exactly what is on page 1. If you look on page 2, the ballot language lists what the Constitutional Amendment language would be. And it omits some things. It shortens it. I think it's just important to have the entirety of up on page 1, line 16 through 22, because the ballot language really it does not get into some of the things that the bill does. So I think just for the sake of transparency, as we look at prevent, continue, end, because it's funny that the Constitutional Amendment just says. This is what the Constitutional Amendment says. This is what it says in the bill. The proposed amendment confirms an individual's fundamental right to an individual's own reproductive liberty, which is not what we have at the page 1. It says freedom on page 1, it says liberty on page 2. and provides the state may not directly or indirectly deny, burden, or abridge the right unless justified by compelling state interest achieved by the least restrictive means. Some of that is what's on page 1, but it's really interesting. It uses the word liberty instead of freedom, and it does not include the part about effectuate decisions to prevent, continue, or end one's own pregnancy. I don't know why you wouldn't want to put that in there, because that's what this is doing. So I think that unless I think we should have what's on page 1, line 16 through 22, be exactly what is on, that should be put down on page 2, line 17 through 20 and substituted. So, Madam Chair, I would move that amendment, and that actually has nothing to do with whether you agree on the issue or not.
I have a motion and a second for a favorable on Reedy Amendment 2. Are there any questions or discussion? Senator Hershey.
Yeah, Madam Chair, my question would be, I think the senator brings up a very good point. Why do we write one thing in the Constitution and then yet put a different question on the ballot? Doesn't make much sense to me on why they would be different. Do we know from previous constitutional amendments if they are written the same on the ballot as they're written in the Constitution?
I mean, I don't know. I don't believe that what the constitutional amendment related to cannabis mirrored the language of the bill that we voted on for the constitutional amendment. I am certain that it did not, but I'll ask counsel to verify
Yeah,
that.
I think that's a little different, obviously, is that was just kind of the legalization of something.
We
And
haven't had this we haven't had this as a constitutional amendment.
this one,
Right.
what we're talking about, correct. But in the Declaration of Rights, this in Article 48, it's very specific on what we're saying will go into the Constitution. I would agree. I'm not sure why the question on the ballot needs to be any different than that same, one sentence, one long sentence, 2 sentences. Why that needs to be any different. I mean, again, we wouldn't expect to put the entire cannabis, bill, 88 bill on there as a question, but this is precise enough that we're putting in the Declaration of Rights that I don't see why we wouldn't have that same question as the ballot question, or that same statement as the ballot question.
Were you,
Oh, I'm sorry, I'm done.
okay, Senator Reedy?
I mean, I'm used to in committees, people on the supporting side, discussing why they support something or why I'm wrong. So this is interesting, but I guess I can ask counsel to tell me why we wouldn't want to put, it's only like one more line of text. So it's not like with cannabis, it was authorizing the legalization of cannabis so we could regulate it. I didn't really like what we had, to be honest, but that was prescriptive. But before that, it used to be you did not put into the bill what the ballot question was, I don't think. So since it's in the bill, it used to be, I think that on some of the ones, I know when we had referendums, which are different than constitutional amendments, the state board of elections got to decide what the language was. And some of us didn't like how they phrased it, but they decided. But if you're going to put it in the bill, why would you? I mean, look, yesterday there was a rally out on Lawyers Mall about how all the things you're doing this session on this particular issue, the folks that were out there. Why, I don't know why we wouldn't want to make it very clear exactly what's going to be in the Constitution since it's a constitutional amendment. I mean, can you help me?
Yeah, I mean, I think the one observation I'd make is that the language that is not included in the description of the proposed amendment that would show up on the ballot, what's not included is the illustrative language regarding the right to reproductive freedom. So what's struck is that the right to reproductive freedom includes includes but is not limited to the ability to make and effectuate decisions.
Well, but it also, if you don't mind me arguing with you for a moment, it also strikes a freedom and puts in liberty, which is a different word. And
so the question is it an accurate description of the constitutional amendment? If that's the test for the voters, then I think that's the key consideration.
I guess, thank you very much. And I guess what I would say in supporting this amendment further is in the language on the first page, it's reproductive freedom. including but not limited to, and then it explains what that is. If on the ballot, you're just saying reproductive liberty and says the state can't, I mean, you know, that could mean I won't be forced to procreate. Well, everybody would say, oh yeah, I don't want to be forced to procreate. I mean, you could interpret that a lot of different ways. So I think it's a good amendment. So hopefully we'll have, I'm sure, strong bipartisan support on just making sure voters know what they're voting on. I mean, you know, I don't know why we'd be hiding it. Thank you.
Senator Mounts.
Yeah, well, this is a tough voting session, and it is a process. And I can't imagine being in the majority to have to make a decision on the amendments that are being proposed today, because I think all the amendments that are proposed don't undercut the constitutional amendment. So it's a tough discussion, and I hope that if they aren't, the two that have already been rejected, and I think this third one doesn't look very the things aren't looking rosy for it. But this is the beginning of the process, and as we move forward, especially not having the opportunity to consider this and review it and think about the implications and the arguments for it, the logic. Hopefully that everybody will keep an open mind, and again, I just wanted to speak in support of this amendment. I want to go off protocol, but I just hope that the process, you know, would maintain an open dialogue. So I also think that the printing of the ballot question ought to be as close to as possible as what the amendment would be. So thank you.
Thank you, Senator. I don't see any further discussion. So we have in front of us Reedy Amendment 2.
Yeah.
All those in favor of the amendment, please indicate by raising your hand. Okay, thank you. Those in opposition, please raise your hand. Okay, that amendment fails. All right. So we have in front of us. Yeah, we actually had a motion and a second on the favorable. Is there any further discussion? All those in favor of the favorable, please raise your hand. Okay. Any opposition, please raise your hand. Okay. That bill receives a favorable report. Next bill.
Don't think you'll see those again, do you?
Okay, the next bill on your list is Senate Bill 591. This concerns legislation, or this concerns a law that was enacted a couple years ago that outlawed non-compete clauses in employment contracts for folks who made either less than $15 an hour or $31,200 annually. This bill amends that language and would say going forward that this section applies to an employment contract or similar document or agreement concerning the employee owns equal to or less than 150% of the state minimum wage rate established under another section of the labor and employment article. So instead of saying $15 or $31,000, as long as you're under 150% of the minimum wage rate, you cannot have a non-compete clause in an employment contract.
Okay, are there any questions on Senate Bill 591? Any discussion, or I would entertain a motion? Have a motion and a second on a favorable. That was Ellis and Lamb. Any questions on the favorable motion on Senate Bill 591? You have a question?
No.
Okay. All righty. All those in favor of Senate Bill 591, please raise your hand.
I was trying to talk myself in.
Non-competes. All right.
We already have them, so it just moves them.
Any opposition?
So low paying folks.
Believe that bill receives a unanimous report.
People
Next
think you-
bill, David.
The next bill is Senate Bill 672. It's a statewide alcoholic beverages bill that authorizes adult students who are not of legal drinking age, adult college students who are not of legal drinking age in Maryland, to taste without actually consuming alcoholic beverages while participating in educational classes such as enology, fermenting, brewing, or hospitality and tourism at qualified institutions of higher education in the state without criminal penalty to the student, instructor, or college or university. Tasting may only occur during the college course or program, and the student must be at least 18 years of age. No alcoholic beverage license is required for this purpose, hence the reason for this legislation. And corresponding changes are made to the criminal law article regarding underage drinking.
All right. We have,
Move favorable.
we have a motion and a second for a favorable on Senate Bill 672, a pro-education bill for the. All right, are there any questions or any discussion?
I would just like
Vote
to
again.
say, we're all chuckling and everything, but it's really a very serious bill, and I'm trying to keep a lid on it. Thank you.
Okay, any further discussion on Senate Bill 672? Seeing none, all those in favor of Senate Bill 672, please raise your hand.
Yeah.
Okay, that bill receives a unanimous favorable report. We'll move to the next bill.
Senate Bill 827, this is a reintroduction from last year that sort of didn't make it through sine die. It extends the termination date of the State Commission of Real Estate Appraisers, Appraisal Management Companies, and Home Inspectors to 2026. And it requires the Department of Labor to do a study, as you'll see on page 2 of the bill, of these companies and some of the practices that have been undergoing regarding appraisals in certain parts of the state. It also requires the Department of Legislative Services Office of Program Evaluation and Government Accountability to assist with the development or with the contracting of the entity to do the study.
Okay, so I'll entertain that motion and second on the favorable. Are there any questions regarding 827? Seeing no discussion, all those in favor of the favorable on Senate Bill 827, raise your hand. That bill receives a unanimous favorable report. We'll move to the next bill, which is Nathan.
Next bill on the list is Senate Bill 136. This is a bill that was heard on February 21st. So the bill limits the amount that the Secretary of Labor may deduct from the weekly benefits payable to an uninsured, unemployment insurance claimant when recovering overpayments that are unrelated to fraud. So specifically, the Secretary may only deduct up to 50% of the weekly benefit payable to the claimant in the future, or if the weekly benefit amount is $100 or less, up to only 25%. Other overpayment collection options remain unchanged. There are no amendments to the bill.
I would just like to make one amendment. You said I could do it without having it. Just move the date to April of 2024. And the reason being is with the new labor secretary, I thought it would give her time to look at all the other unemployment issues, and that will roll it all in.
Senator Klausmeier, if I may summarize the amendment request. So that would be to move the effective date of the bill from October 1, 2023 to April 1, 2024. Is that correct?
Yes. For the reason I said.
Okay, do we have a motion there?
There was a motion on the amendment and a second. Any questions on the amendment, which changes the date to allow the department time to implement the provisions of the bill? All those in favor of the amendment,
I'll look at it.
raise your hand. Any opposition? All right, that amendment is adopted. We now have before us Senate Bill 136 with an amendment. I'll entertain a motion.
Yes.
Favorable with amendments. All those, any discussion on the favorable with the amendment? All those in favor, raise your hand. Unanimous report.
So next on the list is Senate Bill 726, and you'll notice a theme for the next four bills related to health occupations boards. In all cases, the chair is offering an amendment to sunset the boards in 2025 at the request of the department. And so the bills were all heard last Friday. And if you'll recall, the department explained that the amended termination date is necessary in order to facilitate an MDH evaluation of the boards to assess ongoing concerns related to things like licensure technology and administrative functions. So the reprints that you have for these bills are all stapled together for you in a packet. Up first, as amended, Senate Bill 726 extends the termination date of the State Board of Examiners of Psychologists to July 1st, 2025, and includes the amendment that I just described.
We put them all on a consent calendar. Vote
Do you want to just read them all?
Sure.
I'm game.
Senate Bill 727 extends the termination date of the State Board of Physical Therapy Examiners to July 1, 2025. Senate Bill 728, as amended, extends the termination date of the State Board of Examiners in Optometry to July 1, 2025. And finally, as amended, Senate Bill 731 extends the termination date of the State Board for Certification of Residential Child Care Program Professionals to July 1, 2025.
Okay, so I will entertain a motion on Senate Bill 726, 727, 728, and 731.
Move favorable.
Have a motion and a second for a favorable as amended on those four bills. All those in favor, raise your hand. Unanimous report. That concludes our voting for today. Guys, please stay tuned. We're going to be posting and probably putting together voting lists on a daily basis. So we'll try to get those emailed out to you. We have a shorter bill hearing tomorrow, probably. So maybe we can get some voting in if we can get some bills ready. Yes, sir.
try to make sure we do the best we can. Like the ones that we but it's hard on doing something.
I think the only one we voted on without paper in front of us was the date.
Like those are the.
That date change, that's yeah. So in general, I think we have as a committee, I don't think we voted on anything else without paper. We held it at the request of a senator on this committee.
And if we're voting tomorrow, can we get all those good Kramer bills on the board? That'll make Steve Hershey very. Good Kramer bills, I haven't heard of them.
Thank you all. That concludes our work for the day.